For being here today, folks. And as Allison mentioned, we do have at least one, maybe a few more remote attendees. And we're also recording the session, so it'll be available later. I'm sure that Allison will send out information about where it's going to be available. And thank you to the Center for Faculty Development and Excellence for helping to organize and promote this workshop, and for allowing me to have some time to deliver it. As Allison said, my name is Jody Bailey. Please feel free at any time. I don't really like super formal presentations, so if you have any questions at any time, please feel free to just wave and ask those questions. If I don't notice you waving, yell at me, that's fine. You can see my contact information here on the front, the opening slide. And also available is a short link, a bit.ly link that will allow you to access the slides, and you can either save them as a PDF so you have access to them later, and because there are some links on the slides that might be helpful to you, so it may be a good idea for you to go ahead and get to those slides when you have access to a computer. And then I guess we'll go ahead and get started. So today the plan is, for some reason it's not going forward, but there we go. Okay. Today our plan is to talk about some basic definitions, because you can't really talk about publishing agreements and contracts without understanding a few things about copyright. I also want to talk about open access a little bit, because that's an important consideration in publishing these days. And then we're going to look at some publishing models and contracts, as well as some language and terminology that's frequently used in publishing contracts. So that is our roadmap. And I do want to also start with a disclaimer. And that is that I'm a librarian. I am not an attorney. I cannot provide legal advice. So if you have questions about contracts you're dealing with, you're welcome to contact me, and I can give you some information resources, either from my own head, or I can give you some stuff online that you can look at. But if you need actual legal advice, legal counsel, I definitely suggest you consult an attorney. Okay, so again, some basic information before we get started. Let's just, so we're all sort of on the same page. When I talk about journal publishing or publishing in journals, I usually like to think of dividing journals into 3 categories. And they don't always neatly fall into each of these categories, but most journals will. So we're all familiar with the traditional category that is a subscription-based journal. In other words, you cannot access it unless you belong to an institution that subscribes to it, or you subscribe to it individually. It is behind a paywall, we often say, right? You have to pay to access it. You have to pay to read. On the opposite end of the spectrum, I have an example here. This example is the American Historical Review. This example is from the American Medical Association, and it's their fully open access journal called JAMA Network Open. So this journal is completely free for users to access. You do not have to subscribe to it. Anything that's published in it is immediately openly available and accessible to anyone with internet access to read. You don't have to belong to an institution to access it, none of that. So in between, there's a category that we call hybrid. And hybrid journals, as you might guess, are a combination of traditional and open access. So they will have some articles that are subscription only. They're only accessible to subscribers, either folks who belong to universities or other institutions that subscribe, or people who subscribe individually. And they will have some articles that are immediately fully open access, not behind a paywall. Anyone can access them. So this is going to become kind of important, and I might be using these terms throughout the presentation today, so I wanted to make sure, again, that we're sort of on the same page from the beginning. So again, we need to start with some basic information. What is copyright? So You can think of copyright like a pie. Copyright is a bundle of rights. It's not one thing. It is a group of things. So if you have a pie, say you made a pie, apple pie, you can choose to keep all of that pie for yourself and not share it with anyone else. And if you do that, that would be analogous to traditional copyright, all rights reserved, right? So you're keeping all your rights for yourself, you're not sharing them with anyone. However, in open access publishing, you can choose to share some of those rights without giving away your copyright. You retain your copyright, but you're licensing out some of those rights. So some of the rights, in fact, all of the rights that are contained within copyright law in the United States, and I probably should have said that at the very beginning. I am talking about US copyright law. Copyright law varies in different countries, right? So this is US. All of the rights that are contained within US copyright law that you as a copyright holder have, you have the right to make copies of the thing that you own, to distribute the work as you see fit, to prepare derivative works. So an example of a derivative work might be a translation. So say you write something in English and you want to also provide it to people in Spanish, you could translate it. That is a derivative work. For the next one, it's not really something we commonly think about with journal articles, for example, but for other types of work, especially fine arts, so theater, music, painting, sculpture, things like that, this right is contained within copyright to publicly perform or display the work. That belongs to the copyright holder. You also have the right to license any of the above rights to third parties, as well as transfer the copyright to a third party. And again, this is one of those slides that has a link to more information, and you're welcome to explore that further on your own. When is copyright created? Some people are under the mistaken notion that you have to file some sort of paperwork with the US Copyright Office in order for copyright to be official and legal, and that is not the case. Copyright is actually fixed at the moment the work at the moment the work is fixed in a tangible medium of expression. So Sarah is taking some notes in her notebook. Since she has notes, things that she has written down, those things could be copyrighted to her if the copyright, if the legal structures in the United States determined there was enough originality in those notes. So there has to be a level of originality and creation. In fact, data often is not copyrightable because, like the phone book, for example, it was never under copyright when people were commonly using phone books because it's just simply data. There's no creativity. But it is created at the moment the work is fixed in a tangible medium of expression. So if you want to be able to protect your copyright in a court of law, it may be a good idea to go ahead and file for formal recognition from the US Copyright Office. And you are able to do that as an individual, but you don't have to in order for copyright to exist around your work. This is really important information as well. So copyright lasts a very long time in the United States and frankly in most other countries in the world. Copyright lasts for the life of the author plus 70 years. So for something that you create when you're a young person, that copyright could well exist for up to 150 years. So it can be that the length of the copyright term can be problematic at times, and we'll talk a little bit more about that. So I'm going to move to open access because, as I said, in today's publishing environment, it's really important that you have an understanding of what open access is. And I'm also going to talk a little bit about why you might want to consider publishing open access instead of publishing in a traditional journal where you have to transfer your copyright. So open access, this definition comes from SPARC, and SPARC is the Scholarly Publishing and Academic Resources Coalition, Here they're talking specifically about research articles, but there are many, many things that are published open access outside of research articles. So it is the free, immediate online availability is one really key part of that definition of works, in this case research articles, coupled with the rights to use these works fully in the digital environment. So open access, because there are many things out there that are freely available on the internet, right? You could go to the Washington Post website. Well, that's probably not a good example. They actually restrict their resources. But say CNN or another news website like NPR, you can go to that website and find information without having to pay for it, right? So it's freely available, but at the same time, it's not open access because it's published under traditional copyright. You could not reuse that work without infringing on the copyright of the news organizations that produce that work. So, how does open access differ from a non-open access journal in terms of copyright? When you publish in an open access journal, you are allowed to keep your copyright. So you continue to own the work that you produced, and the work, basically what you're doing is you sign an agreement with the publisher that gives the publisher permission, so you are licensing part of your copyright to make copies and distribute that work, right? So remember how we defined copyright as a bundle of rights a few slides ago? And I said you can give permission to third parties to do some of the things that is part of that bundle of rights. So this is what you're doing when you publish open access. You are keeping your copyright, you're keeping the ownership of your work, but you are licensing another entity to distribute and make copies of that work. And you're giving them usually a few other permissions as well. Things like you might give them permission to edit the work, right? To do copy editing on it, for example. For non-open access journals, or what I sort of defined at the beginning as traditional or subscription-based journals, usually, not always, because nothing is ever really super clean or neat, but usually you are signing away your copyright. So usually, traditional subscription-based journals require you to transfer your copyright to them in order to publish your article. So this means that you do not own your own intellectual property anymore. You are giving it away to a third party, okay? And you cannot openly share or reuse that work without permission from the publisher. Does that make sense? Okay. So here's my point of advocacy. I can't stand up in front of a group of scholars and talk about publishing without at least having one slide devoted to advocating for open access. So open access has many advantages. It has some disadvantages too, but you might want to consider open access for some of these reasons. So if you need to reuse your work, say you publish a journal article or a book with a figure in it that you want to be able to reuse, maybe you need to slightly modify that chart or graph or photograph or whatever it may be, and use it in a subsequent work. If you publish in a traditional journal where you sign away your copyright, usually that means you would have to ask permission from the publisher to reuse any part of that work. And many times, not always, but many times the publisher will ask you to pay. Okay, you have to pay for the right to reuse the thing that you created. So if you have a future need to reuse your work, that might cause some issues. The visibility of your work is also important. So in traditional copyrighted publications, there are a lot of restrictions and rules placed around how you can share your work on the internet. A lot of people don't pay much attention to these rules, and they might share that published PDF, that final version of record, on something like ResearchGate or academia.edu, not realizing they are actually violating the publisher's copyright by doing so. However, when you publish in an open access journal, you can share your work openly and freely. You have that permission from the journal publisher usually to do that. Another good point here is that basically the way I can summarize the next bullet point, the higher citation counts, is that we've been talking about open access now for almost 20 years, pretty commonly in academia. The Budapest Open Access Initiative happened in 2002, I believe, if my memory serves me correctly. And people have been sort of arguing about whether open access publishing leads to higher citation counts for almost that entire time. And there have been, I would say, more than 150 studies, research studies, published on this idea of, does open access publishing actually lead to higher citation counts for the author? I mean, intuitively, it kind of makes sense, right? Your work is out there openly. Nobody has to pay to see it. They can access it freely on the internet. So it would make sense that the citation counts might go up. People might be more likely to find your work and therefore to cite it. Some people have argued that that's not the case. I would say that that has really been decided at this point. There was a very strong meta-analysis that was published last fall that basically said they were looking at dozens and dozens of these articles. As I said, it's a meta-analysis, and they came out with an average citation count advantage of 18%. That might be a little lower in some disciplines. It actually may be much higher in other disciplines. But on average, your open access work is going to get 18% more citations than non-open access work. Another good reason that we might want to think about publishing open access, and in fact, sometimes we can't just think about it, sometimes we don't have a choice. So if you receive funding from certain agencies of the US government, as well as certain private foundations, that funding is tied to a mandate that you publicly and openly share your research results, the results of the research that grow out of that funding. So NIH, CDC, the Department of Energy, the Gates Foundation, the Wellcome Trust in the UK, all of these agencies have rules about open sharing of research results. Now, the rules can vary from agency to agency or foundation to foundation. So for example, Gates requires fully open access, immediate fully open access, whereas the NIH allows you to publish in a traditional subscription-based toll access journal and then openly share your results 1 year later. So they allow a 1 year, what's called an embargo, okay? But you need to be, if you're receiving grant funding to do your research, you should be very, very cognizant of the funder mandates around open sharing. The next bullet point has to do with the cost that we in libraries are dealing with. So journal prices and prices for databases have risen much, much higher than the rate of inflation for the past 40 years. And even libraries such as ours, which actually has a really nice, comfortable budget, as well as the richest library in the world, which is Harvard's, are getting to the point where we can't afford it anymore. And we certainly can't afford the 7 to 10% costs additions that go every single year on top of the $5.1 million that we paid last fiscal year. When you think about how much a 7 to 10% increase is on 5.1 million every year, you can see how it's very quickly getting to the point that this subscription-based model of publishing is not sustainable anymore. The last reason, social justice, has to do with the idea of inclusivity and access for all. So when you think about who might want to access your research, especially if you do research in medicine or social work or psychology or other fields where there are a lot of practitioners out there that may not be attached to a large research institution where they can get access to research that way, then it really does become a question of in people's lives in terms of medicine in particular, right? That people in developing nations or people in the United States, as I said, who are not attached to a large research institution such as a hospital or a university that can afford these subscriptions, they need to have access to this work. And even if you're in humanities and it's not a matter of life and death, it still is a matter of increasing access to knowledge around the world, right, for our colleagues and folks that we want to talk with. So, I talked about publishing open access versus publishing in a toll access journal or a subscription-based journal. So in a subscription-based journal, you transfer your copyright to the journal. They publish that work under an all rights reserved traditional copyright license, okay? Because you've given them your property, you no longer own it, they can do what they want with it. They normally publish it that way, under traditional copyright. However, if you publish in an open access journal, you're usually going to be giving that, you're keeping your copyright, as I said, and you're going to be giving some permissions to that journal to share your work in various ways. This is the most prevalent license that's used on open access published work, and it comes from a nonprofit organization called Creative Commons that was started, I don't know, 15 years ago, something like that. If you ever heard of Lawrence Lessig, he's a professor at Harvard, a law professor at Harvard. He started this group, this nonprofit organization to create something that was desperately needed. And basically, as I said, in the early 2000s, when we started talking about open access, there was no way to openly share your work with permissions. You could only share your work under traditional copyright. There were basically two polar opposites, right? You could share your work under traditional copyright, all rights reserved. I'm not giving anyone any permissions unless they ask me. Or I can share my work as a public domain work. I can literally say, I want my work to be in the public domain. Anyone can use it. You don't have to ask me permission. You don't even have to credit me as the original creator of this work. There was nothing in between, okay? So Lawrence Lessig comes along, creates this group called Creative Commons, and these are literally legal licenses that you can attach to your work that tell people who see your work how they can use it. In other words, you're giving permissions in advance for other people to use your work. And you may have noticed that I have a little CC BY symbol down here on the right side, bottom right corner of my slides. So that is my code, for those who are aware of Creative Commons licenses. That is the way I've licensed my work. I've put a CC BY license on it. So you can see that at the top, CC0 is basically equivalent to public domain. CC BY is the next most permissive license. And what I'm saying by putting a CC BY or a CC or Creative Commons attribution license, it's also called, on my work, is that I would allow anyone to reuse it in any way they like, verbatim if they like, can literally copy my slides, give the same presentation I'm giving. All they have to do is attribute me as the creator of these slides, okay? If I wanted to have some say in how a downstream user might license their work, I could put the next license on it. So I could say, not only do you have to attribute me as the creator, you have to share your work with the same permission that I put on my work. So share alike is the SA portion. And you can see that there are varying degrees until you get all the way down to CC BY and CND, which is the least, it's the most restrictive form of a Creative Commons license. So that means you have to attribute me, you cannot use my work. Anything you create that's based on my work cannot be used for commercial purposes. You can't make a profit off of my work, nor can you make any derivative work. So ND is no derivatives. So you couldn't translate it, you couldn't change it in any way. Say I published a photograph and I put that license on there. You wouldn't be able to crop the photograph however you like. If you wanted to reuse it, you would have to reuse it exactly as I created it. So these are ways that you can, these are licenses you can put on your work that you own the copyright for, and basically telling folks how they can reuse it. Any questions about that? Okay. As I said, yeah.
The symbol you have at the top there, it looks like it's 0
Mm-hmm.
with a line through it, but that's not what you used on your slide.
No.
Does it mean the same thing?
They don't mean the same thing. So CC0, it means that anybody could reuse my work and they don't even have to attribute me. It's like public domain.
Okay.
CC BY is the Creative Commons Attributions License. By, it's like by Jody Bailey, right?
Okay, I see.
So the difference is they could reuse my work in any way they choose, but they have to attribute me as the original creator. So these, as I said, this is the most prevalent type of licensing systems that is used in open access publishing. Sometimes publishers, if you publish with an open access journal, will dictate the type of license that's going to be put on your article. Sometimes they allow you to choose, okay? So if you ever have any questions about how you might want to choose what license to put on an open access work, you are welcome to contact me. I wanted to also talk a little bit about why publishers want copyright. Why do they ask you to transfer copyright to them? Okay. So the argument that they make is it's necessary for them to have copyright in the work that they publish in order to protect you from copyright infringers. So that they're trying to protect you, is what they tell us, right? And there probably is an element of truth to that. Publishers do go after people who infringe copyright, but they can only do that if they own the copyright. They must own the copyright in order to go after an infringer. So there is an element of truth here, and I don't mean to imply that there's not. But there's also another motivation. And that motivation, particularly for commercial for-profit corporations that publish academic work, is money. If they own the copyright, they can charge people anything they like, whatever the market will bear, to reuse parts of that work, okay? So not only can they charge for reuse of parts of the work, they obviously are selling it, right? They're outright selling the work. So they sell subscriptions to libraries at academic institutions. For those individuals that might want to access an article who don't belong to an academic institution, how do they get access to these articles? Well, there are various nefarious ways to do it that are not legal. There's a particular website out there that has millions upon millions of research articles that are pirated. We would hope that people don't do that, don't go to a pirate site to get articles. However, if they want to do it the legal way, they've got to go to the publisher's website and pay for the article, okay? And as probably most of you know, for one research article at a given publisher's website, the charges are usually anywhere from $15 to $30, maybe $40, right, for one article. That becomes very expensive if you need to access a lot of articles. So, another thing that I definitely want to mention as part of this presentation is that there is a wonderful website called Sherpa Romeo that gives you a lot of information in a very compact space about what and how you can share. So if you publish, and this is whether it's, I guess open access journals are listed here, but open access journals have such permissive policies, they may not be. But many journals have such a varying amount of policies that it can be an incredibly complex thing to figure out. What can I actually share openly? So this is copyright policies and self-archiving on this website called Sherpa Romeo, which is maintained by a research organization in the UK, a nonprofit organization. You can go here and search on the journal title and find out. It'll give you actual information about what and how you can share. So we're going to talk a little bit. Let me see where I am. Okay. I'll talk a little bit more about this in a minute. For now, I want to talk about common parts of contracts. So these three sections are three overview sort of terms are the sections of contracts that you're most likely to run into. And there may be others, and they may not use these exact words, but most of them contain these sections. So the first one is the grant of rights. For a subscription-based journal, this is where the publisher is going to ask you to transfer your copyright to them. And usually they have to use words like transfer of copyright. That's legal language. If they're not asking you to transfer copyright and you're publishing in an open access journal, this is where they're going to list the things that they need to be allowed to do. So it should explicitly say that you are going to retain your copyright, but you are giving them permission, or you are granting a license, sometimes those words will be used, for them to make copies and distribute your work, and they may have a lot more language around that, sort of listing all the ways that it might be possible for them to distribute the work. And these days, with the various types of distribution that we have, that can be kind of a long list. But that's kind of what that section of the contract will say. Another section is going to be something called representations and warranties. So these are common representations and warranties that are part of a contract that you are going to sign, that you need to make sure you understand. First, it's going to say you're going to be asked to verify that your work is original, that you're not copying it from anyone else, that your work does not contain any libelous or defamatory information, because the publisher doesn't want to be in trouble for publishing libelous information. That there's no violation of the privacy rights of individuals, and that's obviously becomes very important in human subject research, like if you're doing health research, right? And that if you are using any materials that come from another published source, that you have obtained permission for the reuse of that material. So if you're reusing an image from another publication in your article, then you have to show that you have obtained permission. Or if it's an open access publication, you need to show what kind of license that it was published under. And then there'll be a section called retained rights. And these are permissions that you retain when you transfer copyright. And these vary widely from publisher to publisher. So if you are being asked to transfer copyright, many publishers, there's a spectrum. Some publishers are incredibly strict and basically don't allow you to retain any rights. And some publishers are much more liberal with what they allow you to do later with the work that you created but no longer actually own. So here's where I said I would talk a little bit more about Sherpa Romeo. There's this concept of a preprint or a submitted version of a journal article. So that is the draft as it was submitted to the publisher originally. And then there is the postprint, which is the version of your article after it has undergone peer review and revisions. So it's sort of your final manuscript before the publisher takes it and makes it look pretty and perhaps does some copy editing to it. But it's really, the content is in its final form. It's just not been laid out, right, and ready for publication. So preprint is your draft as it's submitted to the publisher. It's sometimes called the submitted version or the author's original manuscript. Then you'll see these words postprint, which I think is very confusing because to me that implies that's the version sort of after it's been printed. So people are trying to get away from using that term because it's so confusing for so many people, and using author's accepted manuscript or accepted manuscript. This is the version, again, after peer review, after any revisions have been done, and it's been accepted for publication. And then the other version that's talked about is the version of record, and that is the publisher's final version after it's been prettified and copy edited, and it's actually what appears on the publisher's website. So that final PDF copy, right? So those three things are the three versions that you will see language in contracts around what you can share. Because sometimes publishers allow authors, even if they transfer copyright, they allow authors to share the preprint version of their article openly anywhere they're like on the internet. Okay? So that's the preprint. Sometimes, even when you transfer copyright, the publisher will allow you to share the postprint or accepted manuscript version. So this is the version without any of the predification done. You could share that manuscript on an institutional repository here at Emory. As Allison mentioned at the beginning when she was introducing me, my team maintains and administers the Open Emory Institutional Repository, where we have over 15,000 journal articles by Emory faculty that we have shared. Either they have been published open access, so we can share them there in their final version of record form, or they were published with the publisher's permission to share a post-print version or an accepted manuscript version. Often, because of funder requirements, we might be sharing that author-accepted manuscript for NIH-funded research, for example, okay? So that fulfills the funder mandate. So this is where it gets very complicated and where a lot of authors get confused and they just don't really understand that there's three different sort of versions of the article, and the publisher may be granting different permissions for different versions of articles. So people usually just say, I don't understand it, I'm gonna share the PDF on ResearchGate, and if they don't like it, they can come after me, right? I know, like the vast majority of people, that is what they do. But if you have transferred the copyright of your article to a publisher, it's highly unlikely that you have permission to share from the publisher as part of the publication contract to share that version of record on something like ResearchGate or academia.edu. Embargo, as I mentioned this term earlier, is a period of time during which an article may not be shared. So often publishers traditional publishers will say, you cannot share the accepted manuscript version of your article until 12 months after it's been published on our website. So you must allow it to be there on the commercial publisher's website or the university press's website for 12 months, 24 months, sometimes as long as 48 months, and then you can share your accepted manuscript version of the article. Yes?
So are these, I guess, deciding which level of copyright, is that negotiation that takes place after your manuscript will be accepted in the journal, or is it something you negotiate prior to considering a journal?
Well, with the publication contract, that language will usually be in there. So it's not something that you're gonna have to bring up. The publisher will have already have that language in the contract. And Sherpa Romeo, as I said, is a really good website to go to find out exactly in a very compact form, you know, exactly what the publisher normally allows. Now, you can negotiate this. So, when you are getting ready to publish, if you don't like the terms of your contract, you can definitely negotiate. Say it says, I want to be able to share my accepted manuscript version of my article within 6 months of publication, rather than waiting, say maybe they're asking you to wait 48 months, 4 years, right? And you don't want to wait 4 years. You want to be able to share it earlier than that. You can ask for that. And they will tell you yes or no. And what most faculty don't realize is that after your manuscript has been accepted by a journal publisher, it behooves the publisher to make you happy, because they have put a lot of time and effort into peer review, and then maybe looking again at the revisions to your article and all of those things. They have invested time and money in you and your article. So you are in a position, at least somewhat of power, right? That you can ask for different terms of a publishing contract. And that again is something that I could help you with, okay? So some open access journals, the way they work, because, I mean, if you think about it, they're not asking readers to pay to read the work. So the business model is different for some open access journals, and this is not the case for all open access journals. But some, particularly in the STEM fields, ask authors to pay what's called an article processing charge. And that is it's a subvention, basically, to pay for the publication of the article. So it helps to support the journal. So if you want to publish in an open access journal, but you don't have the money to pay that fee, if there is a fee, you can apply for funding from our Open Access Publishing Fund. Now this is, I will state, a fund of last resort. So it is not something that if you have grant funding available to you, you're not going to be eligible for this funding. Okay, so I have an activity for us